Hi, I'm Kieran, and I'm going to be talking about data subject access requests, DSARs. Now, there are many surprises that can strike dread into the heart of a lawyer, and DSARs are well up there. Under Article 15 of the UK GDPR, people can request a copy of the personal data that a controller holds about them and information about how that data is processed. And whilst this is a key right under the GDPR, responding to DSARs can be incredibly complex, time-consuming, and expensive. Fortunately, we have two recent court decisions that provide some helpful guidance. Now, in my experience, there are two types of people who submit a DSAR. The first type is employees or former employees of companies seeking leverage to bring an employment claim. And secondly, very rich people who aren't happy with how things have turned out for them. And both of the cases we're going to talk about fall squarely into that second category. So first up, we have Mike Ashley in HMRC. So HMRC investigated Mike Ashley and found he had acquired some properties at an overvalue, leading to a tax liability of over £13 million. So he submitted a DSAR to the department that led the inquiry at HMRC, asking for all of the information it had about him in relation to the inquiry. A mere 2 years later, he received their response. Unsatisfied, he brought a claim. Now, despite HMRC having spent hundreds of hours on this DSAR, the court found that it had taken too narrow an approach and ordered it to reconsider the whole response. So, what went wrong? Well, firstly, the court found that HMRC failed to carry out a reasonable and proportionate search for the personal data as required, because it had limited the search just to the department within HMRC that led the inquiry, rather than considering all locations where in-scope data for which it was a controller may be held. Now, helpfully, the court clarified that when deciding what constitutes a reasonable and proportionate search, controllers can consider all the practical difficulties that come with preparing the response beyond just carrying out the search itself. So that includes time taken to consider applicable exemptions and then to redact data accordingly. Secondly, HMRC had taken too narrow an approach in deciding what information constituted Mike Ashley's personal data. Now, he argued that because the tax inquiry was solely about him, all of the information about the inquiry was his personal data. The court rejected this idea and confirmed that information can constitute personal data by virtue of its content, effect, or purpose. So here, information such as how those calculations of the overvaluations had been arrived at, despite not directly pertaining to Mike Ashley, was considered his personal data and should have been disclosed. Thirdly, HMRC failed to provide sufficient context to the extracts of personal data they provided him, such that he could understand why and how his personal data was being processed. And finally, HMRC had sought to rely on an exemption under Schedule 2 of the Data Protection Act, under which information can be withheld if its disclosure would likely prejudice the assessment and collection of tax. HMRC hadn't actually established why the disclosure would be prejudicial, so they couldn't rely on that exemption here. So, good news for Mike Ashley, but the claimant of our second case was less happy with the outcome. So the case of Harrison and Cameron concerned a billionaire, Mark Harrison, who was embroiled in a payment dispute with his gardener, Mr. Cameron, and his company ACL. Mr. Cameron secretly recorded conversations with Mark Harrison about the dispute and shared those recordings with some of his family members, friends, and colleagues. Those recordings ultimately ended up in the hands of some of Mr. Harrison's peers, and he believes that this led him to losing out on a lucrative business deal. So he submitted lots and lots of DSARs to find out who Mr. Cameron had shared the recordings with. Now, you might be wondering, what could possibly be so bad about these recordings? Well, here are some snippets from the transcript. You are too stupid to follow instructions. I will send some people to pay you a visit you and your family will never forget. And my personal favourite, I will see you in a couple of hours and we will thrash it out, thrash being the operative word. To a gardener. So when Mr. Cameron refused to provide the names of the people he'd shared the recordings with, Mark Harrison took to the courts, and I imagine these journalists had great fun coming up with these headlines. The central question in this case was whether Mark Harrison was entitled to know the actual names of the recipients of the recordings, or simply the mere categories of recipients under Article 15(1)(c) of the UK GDPR. The court applied the reasoning of the European Court of Justice in the Austrian Post case and decided that, although it's unclear from the wording of the provision who gets to decide, as in whether it's the controller's choice or the data subject's choice, the controller should provide the actual identities of the recipients unless it's impossible to do so, or the request is manifestly unfounded or excessive. Here, the court held as, because there were only 15 recipients of the recordings, Mark Harrison was entitled to know their names. However, the court also held that ACL was entitled to rely on an exemption under Schedule 2 of the Data Protection Act that provides that personal data can be withheld from disclosure where disclosure would unreasonably infringe the privacy of other people who can be identified from that information. And the court emphasised that the controller is the primary decision maker in that assessment and has a wide margin of discretion to decide what factors are relevant and how much weight to give each one in deciding whether it's reasonable to disclose the information or not. Here, this included the fact that Mr. Cameron had offered to tell Mark Harrison who he'd shared the recordings with if Mark Harrison undertook not to threaten or harass them, an offer which he had refused. So, these cases are useful to bear in mind when navigating your next DSAR. Thank you.